Hi everyone, in this video we are going to see what is a contract and what are the essentials of a valid contract. According to the Indian Contract Act 1872 under section 2H, an agreement which is enforceable by law is a contract. So before knowing about the contract, we should know the term agreement in depth. When an offer is bounded with an acceptance, it comes as promise. Both the persons, when they are exchanging their reciprocal promises with some amount of consideration, it is agreement. When this agreement is enforceable by law, it comes as contract. Then what is this valid contract? When this agreement is bounded with essentials under section 10, it is valid contract. So what we understood from this, for knowing about contract, we should know agreement in more detail. Agreements are of two types: enforceable agreements, unenforceable agreements. Enforceable agreements are clearly those agreements which are enforceable by law and it comes as valid contract. Unenforceable agreements are three types: domestic agreement, social agreement, void agreement. Domestic agreements is nothing but when two parties enter into the contract, they should have the legal relationship between them, otherwise it comes under domestic agreement. Social agreement, like a domestic agreement, social agreements also does not comes any legal relationships, but some agreement will be there. For example, I invited you for lunch to my home, but I was not available at my home. So, at that case, you can't sue anything upon me, as because we have not undergone any agreement or legal relationship. Next, void agreement. Void agreements can be occurred due to many reasons, like illegal relationships, agreement with a minor, etc. Now let us see essentials of a valid contract. These 10 are the essentials of a valid contract. Now let us see one by one in detail. Offer, legal offer and acceptance. When I am giving some offer to you or a proposal to you, when you are accepting it, that becomes when it undergoes with some legal relationships, it is known as legal offer and acceptance. If a person offers you an offer, he is known as offerer, and who accepts it is known as offeree. When the offeree accepts that proposal, he becomes as acceptor. Next, intention to create legal relationship. Both the parties, when they are entering into the contract, they should have legal relationship. Otherwise, that contract will be not valid contract. Next, lawful consideration. Consideration is nothing but quid pro quo, means something in return. Every party should get something in return. That may be in goods, promise, etc. If I am doing some work to you, in return I should get something for that work. That is consideration. Next, competency of parties. Competency of parties means what is the eligibility or what does the what are the parties should be involved. It should satisfy three conditions. That is, he must be a major, he must be a person of sound mind, means mentally able, he must not be disqualified from contracting by any law to which he is subject. Next, free consent. Two or more parties, when they are agree upon same contract with the same sense, it is called consent. Under section 14, consent of the parties is said to be free when they are not caused by the following: they are coercion, undue influence, fraud, misrepresentation, mistake. Next, lawful object. Object means nothing but purpose of the contract. Why we are performing that contract? What is the main purpose of the contract? For example, if a tenant asks for a room to be rented, in that room he is doing some smuggling. Smuggling means it is a illegal activity. So the purpose, the object of the agreement is illegal. So the both agreement will be invalid. Unlawful consideration and objects are if it is forbidden by law, if it is fraudulent, or if it is immoral. Certainty and possibility of performance. It should have clear definition why we are performing that agreement. For example, here we see A agrees to sell B 200 tons of oil. Here he is not mentioning what is a brand or company of oil he is going to sell. Means the clear information about the picture is missing in this case. So it is a it it is an it leads to an invalid contract. Legal formalities. There is no need of particular legal formalities to perform an agreement. It can be in oral or it can be in writing. Whatever the contract we are performing, according to that case, that essentials we need to fulfill. Next, not declared to be void. The Indian Contract Act itself declared some of the acts as void. They are unlawful agreement, agreement without consideration, uncertain agreements, etc. Thank you.